Well, Edo State politics is next, and the build-up to the governorship election is dying minutes, really, particularly for politicians and the build-up to that election. And there's been a lot of activity. If you're familiar with football, you know that the dying minutes are very vital to the victory or otherwise of a team. Yesterday, there were lots of activities at the court. There have been reactions, but what does this mean? How does it significantly change the outlook for the coming election or otherwise? Well, we're joined on the program by a legal practitioner, Deputy Director General of the PDP Governorship Campaign Council, Mr. Jimoh Ijegba. He joins us virtually on the program this morning. You're welcome to the Morning Brief.
Good morning.
Well, quite a number of issues decided at the court yesterday. Being, of course, a PDP member, you are the vanguard of ensuring that the PDP candidate wins the election and, by extension, the PDP retaining power in Edo State. But there were some major decisions taken by the court yesterday. One, former Deputy Governor Philip Shaiibu being reinstated as Deputy Governor, essentially court saying that that process of his, the process that removed him, null and void. And then the one concerning PDP governorship candidate Asue Ighodalo. But tie this to the previous court ruling that declared the primary process of the PDP as not following due process in the first place. So help us tie these three judgments together. How, well, your interpretation of them, basically.
Thank you very much. Let me start with the two judgments by Justice James Omotosho yesterday. One was the order restating the former Deputy Governor of Edo State, Comrade Philip Shaiibu. Let me say from the onset that the procedure for the removal of a governor or deputy governor is stipulated in section 188, 1 to 11 of the 1999 Constitution as amended. And if you follow it, up to subsection 10 of that section 188, it clearly stipulates that the proceedings by the tribunal set up by the House of Assembly, by the Chief Judge, and the consequent procedure by the House of Assembly is not questionable in any law court. That is one. In Inakoju versus Adeleke decided in 2007 as a result of the removal of Senator Rashid Ladoja, governor of Oyo State. The court clearly stated that the court has jurisdiction to investigate the procedure and not the proceedings. I'm aware, as an active member of PDP, I followed the event very carefully of what transpired in the assembly that led to the impeachment of the former deputy governor on Monday, April 8, 2024. I have not seen the detailed judgment of Justice James Omotosho. I clearly know that the State House of Assembly followed due process and the procedure stipulated under section 188, 1 to 11 of the 1999 Constitution. Now that judgment has been given. Rightly, the State House of Assembly has appealed that judgment. And they have also followed up with a motion for stay of execution of that judgment. As it is today, parties must await the decision of the Superior Court, the Court of Appeal, and probably maybe the Supreme Court on that matter. As it is today, when parties submit themselves to the court jurisdiction, they must exhaust all that is provided under the Constitution for you to now say, yes, you have exhausted the matter up to the apex court, which is the Supreme Court. And rightly, everyone, all the parties have to await the decision that is going to come up from the Superior Court on this matter. Because all I know is that clearly, if the procedure was right, the court does not have jurisdiction. And when I read about it and they are talking about fair hearing, I'm aware that the former deputy governor was served with the impeachment notice. He never obliged with an appearance. He sent a lawyer who now withdraw his appearance along the line. And the House of Assembly followed the detailed procedure as stipulated under section 1.
Mr. Ijegba, are you faulting then the decision of the court?
Well, the court is not a final court. I don't agree with the decision of the court. It's not a final court. And rightly, the Assembly have exercised their right of appeal. They have filed an appeal. They followed up with a notice for stay of execution of that appeal. We have to await the decision of the Court of Appeal and probably the Supreme Court on that matter.
So, Mr. Jegbe, when you say that the court has the right to investigate the procedure and not the proceedings, I wonder what you mean by that. And, you know, some of what representatives of the PDP are quoting in subsection 188 of the Constitution is to the extent that the State Assembly, whatever constitutes, in the opinion of the State Assembly, to be misconduct, then the State Assembly can act on the impeachment of the deputy governor or an executive. But doesn't the Constitution now leave the judgment and discretion to the whims and caprices of elected State Assembly members without granting fair hearing and indeed the court the right to investigate and determine whether indeed an executive has been guilty or not?
There is a procedure that is stipulated in section 188 from subsection 1 to 9. If that procedure is duly followed by one, if there is a notice to the person in question signed by 1/3 of the House of Assembly of that particular state, they can commence the proceedings. And thereafter, when the committee is constituted by the chief judge of the state and they return a verdict of guilty, then the State House of Assembly has a duty to debate it. And when it is carried by 2/3 of the Assembly, then the deputy governor or the governor stands removed. And that procedure, like I said, was followed in this instance. So I don't know the rationale for anyone to say, yes, the procedure was not duly followed. Because if you talk about the proceedings, the court does not have jurisdiction, as stipulated in section 188, subsection 10. Now, as to what constitutes gross misconduct is stated clearly in section 188, subsection 11 of the 1999 Constitution as amended. And that one gives the House of Assembly to determine what constitutes gross misconduct. Now, the House of Assembly has come up to say that we have examined very carefully and the rightful procedure has been followed. But Justice Omotosho, in his wisdom, has said they breached certain section of that Constitution. The Court of Appeal is now being invited to look at the proceedings, to look at the procedure followed by the Assembly. And if it complies, certainly that judgment cannot stand. And everyone has to await the judgment of the Court of Appeal and the Supreme Court.
Mr. Jegbe, Mr. Shaiibu has already said, he said in the past that his removal from office was a dangerous descent into dictatorship and a threat to democracy, even with the pleas and pleas that happened. I mean, we know what happened between Mr. Shaiibu and Mr. Obaseki, and several times Mr. Shaiibu came out pleading and doing all of that. What do you think would have been done differently, preventing us from getting to where we are right now?
Shaiibu was not impeached by Governor Obaseki. But it is the Assembly that have the responsibility to do the impeachment when impeachable offenses are committed. And rightly, when impeachable offenses were committed, he went in. Justice is a three-way traffic. It's both for the plaintiff, the defendant, and the state. It's not for him to conclude to say that it's a descent into dictatorship. It's for the court to now find out whether the rightful procedure was followed. And if it is followed, so be it. It is a closed matter. And if it is followed like that, the court does not have jurisdiction under section 188, subsection 10 of the 1999 Constitution.
Right. So as things stand right now, you're of the opinion that, well, the IGP, because the orders were quite clear, the IGP should return his security details. So are you saying that the IGP should hold off in spite of that court judgment and all of the other?
He is duty bound to hold on. Immediately a notice of appeal has been filed, followed with a motion for stay of execution. He does not have choice in the matter. He has to await the decision. Mind you, if that court goes ahead to refuse that notice of stay of execution, right, the Assembly have a right to go to the Court of Appeal with the same application. So until it is one way or the other. It cannot. The IGP is duty bound to await further deliberation on that matter by Superior Court.
I just wanted to clear that out. But my focus is, the bigger picture. Really, is it too much for the state government, and talking the legislature, the executive, eat the humble pie? Because the gimmick here naturally will be In any case, this government is almost done. So what we'll do is take it to appeal court. If appeal court rules in favor of Mr. Philip Shaiibu, take it to the Supreme Court. Just waste time until this administration is done with its term. And in any case, it's now futile. Fine, he may be paid in arrears and the rest, but isn't that the gimmick as well? And doesn't that just speak to some of the practices that we've always condemned in governance? That, I mean, if this thing is proven to be wrong, just let it go and allow the law to run its course rather than all these tactics at the courts.
No, there is a procedure. There is laid down procedure by our constitution, by our laws. You have to follow it and exhaust it before you think about any other thing. There is no shortcut to it. When you subject yourself to adjudication by the court, you must allow the courts to run its full course before anything. It's not time wasting. He has asked for some remuneration to be paid. If at the end of the day, the final court finds that he's entitled to any payment as a result of unlawful removal, he will be so entitled. But before then, there is nothing anybody can do, because we are a government that is practicing the rule of law. When you say Nigeria has chosen clearly to be on the path of rule of law, it must exhaust the procedure provided under the 1999 Constitution, and nothing more, nothing less.
Well, Mr. Jegba, permit me to belabor the point, particularly because of the weight of allegations that the State Assembly leveled against the impeached deputy governor, including perjury, divulgence of government secrets. So if that were to be the case, and you're insisting that the court has the right to investigate the procedure and not the proceeding, isn't there anything in the Administration of Criminal Justice Act that compels the court to determine that indeed, it's not just one word of State Assembly members against the accused, such that, those allegations can be investigated and proven, to be true before he can be found guilty of the offenses, and therefore then impeachment can stand? I imagine that you would want a fair hearing to, if you were the accused, Mr. Jegba.
Unfortunately, that is not the position of our law. The position of our law is as stipulated under the 1999 Constitution. And that has been fully exhausted. The Assembly have looked at it and found that impeachable offenses have been committed. And they so now impeach the former deputy governor. As it is today, until the Court of Appeal and probably the Supreme Court rules on the application for stay of execution and the appeal, notice of appeal that has been filed, everybody has to await the decision of the higher court on this matter.
Mr. Jegba, let's talk about the dismissal of Mr. Shaiibu's suits seeking Mr. Ighodalo's sack as a PDP candidate. Since you're a legal practitioner, speak to us about your thoughts about that new judgment and the new decision by the court on Aso Ighodalo's case.
Well, let me start from the onset to say that there are two cases. The one that was decided by Justice Ekwo and the latest one by Justice Omotosho. First, I was surprised as to the misinterpretation of that judgment by Justice Ekwo. The parties in that matter were mainly asked to say that don't conduct primary except these 378 delegates participate in the primary. Mind you, as at the time this judgment was being given, our primary was conducted on February 22nd, and the whole world watched a very transparent, free election that took place at Obi Stadium. Then we have this group of delegates who now came up to say they are challenging that except they be part of that primary, the primary should not hold. And eventually, the primary held. And later on, the judgment came. First, under Section 84, subsection 14 of the Electoral Act 2022, only an aspirant who participated in a primary can challenge the outcome. There is nowhere stated under the Electoral Act that a delegate has the locus to go to court to question a primary that has been conducted. It is strange in our law, and there are authorities from the Superior Court up to the Supreme Court, even the one we had in 2022-23 in Edo here, in Iyore and other, The Supreme Court clearly stated that it's only those who participated in a primary that can challenge the outcome. There is nowhere they say a delegate can go ahead to challenge the outcome of a primary. And the orders given by Justice Eko didn't say Aswen was no longer the candidate of the party. A primary has been conducted and concluded. And in law, when an act is completed, you don't go and make an order that is unenforceable. You don't make an order to restrain an order that is completed. There are authorities from the Superior Court, the Supreme Court, the highest court in the land. AG versus John Holt clearly state that an act that is completed cannot be restrained. So Justice Eko, the court is not a Father Christmas. The parties in that matter never asked Aswen is no longer the candidate of PDP. They got an order that was not enforceable. Don't do primary except this 378 participate in the primary. As for the second one that was delivered by Justice Omotojo yesterday, the same Shaiibu went to court to challenge the eligibility of Dr. Aswen Ighodalo to have participated in that primary. And the court clearly held that as the primary was valid, it was free, fair, transparent, and that there is no way any court in the land will vitiate that process, that primary that was conducted in Obe State on February 22nd. As it is today, and as conferred by the people of Edo State, PDP in particular, on February 22nd, Aswen Ighodalo remains the candidate of our great party, the PDP.
Right. Well, Mr. Jagbai, what the justice said, just to reiterate the point and put it in context, was basically voiding the February 22nd primary election on the ground that 378 delegates who were supposed to vote at the primary election were unlawfully excluded by the PDP. And if you say that actions completed cannot be reversed, we've seen even bigger actions that were conducted, even bigger elections, proper elections, governorship elections, and the rest conducted, and the courts went ahead to reverse the outcome of that election, just to put that in context. And that's why we have a court. Even the impeachment of Mr. Philip Shaiibu can be seen to be an action that has been completed already, but currently you are in court to reverse the judgment that was given yesterday, just for our viewers to follow the track of what's going on.
The point I'm making is that if you are asking for injunctive relief, to say restrain, don't conduct primary except this guy, the 378 participate. As at the time the judge was giving that judgment, primary had been concluded. He's aware. It's notorious. It's known to everybody that primary of PDP was conducted. I just
wanted to put the context out there as well, so people can follow all of the angles. But I want to bring this maybe personal. I mean, you are someone that some people say has been given a second chance of sorts. You've been commissioner in this government, at least in the previous tenure, and you're no more commissioner. But that doesn't mean that you're still not a part of the activities, particularly of the party in the build-up to the election. So some will say, well, you're someone who's been given a second chance as well. So will it be wrong to give the former Deputy Governor, Mr. Philip Shaiibu, a second chance at this stage, since you're someone who has also enjoyed a second chance?
Well, if you hold an office of trust, common sense dictates that you must abide by the details of that office you are holding. If you engage in things that will likely bring down the government by way of divulging official secrets, there is the Official Secret Act, then you are not entitled to remain in such type of government. The honorable thing one expects is that he should tender his letter of resignation and go, and shouldn't even wait for the assembly to impeach him. And if you are impeached by the assembly, like I said at the beginning, there is procedure, there is proceeding, as stated in Nakoju's case versus Adeleke. Mind you, in that case of Adeleke, it was even the legislators who went to court because some few legislators gathered in a venue outside the building of the House of Assembly to impeach Senator Rashid Ladoja. And the court said no, the proper procedure was not followed. In those cases, the proceedings took place in the House of Assembly, where the notice of impeachment was raised, served, and the man bluntly refused to make himself available to defend himself. But mind you, the Constitution also provides that you can either defend yourself in person or by a legal practitioner of your choice. And he exercised that option of engaging a professor, a senior lawyer, senior advocate of Nigeria to represent him at the tribunal proceedings. Along the line, he backed out. Then if you are talking about fair hearing, what do you mean by fair hearing? That you were served, you were entitled, you engaged a legal practitioner to represent you, who along the line decided to withdraw from the proceeding. I do not understand the context of fair hearing.
Well, Mr. Ejegbai, there are so many angles to this, but I do have what I believe to be the certified true copy of that judgment by Justice Kelvin Mohammed. And it does describe the delegates as lawfully elected ward Congress delegates in their respective ward. And it says by virtue of which the defendants cannot exclude them from participating at 3 ad hoc ward at the governorship primary election, of the Edo State slated for the 22nd of February. The judgment also goes on to say, and it describes that, by the way, as a declaration by provisions of Article 50 of the Constitution of the second defendant. Now, the judge, honorable judge, also goes on to direct the defendants who are bound by provisions of Section 82 of the Electoral Act 2022 yes. to allow the 3 ad hoc delegates to participate in the primary. So what is your interpretation of paragraphs 2 and 3 of these, this judgment by the honorable judge?
As at the time that judgment was being given, the whole world is aware that possible, it becomes an academic exercise. If you say don't exclude them in the primary to be conducted on February 22nd.
Is that your own interpretation?
The position of the Electoral Act is that it is someone who participated in a primary that can challenge the outcome. There is nowhere from beginning to the end of the Electoral Act that qualifies a supposed delegate to go to court to challenge what is happening about the primary.
Mr. Ejegbai, by the provision of this honorable court, are you describing them as supposed delegates or are they lawful delegates?
They are not lawful delegates.
So you disagree with the judgment of the court that they are lawful delegates?
The ad hoc delegates election was conducted in the 192 wards. They didn't participate. They never won. They gathered themselves somewhere, like one of the judgments stated. He gathered people in his house and said he was doing delegate on his own. A student setting exam for himself, marking them, and coming forward to say, I am the one who has the authentic delegate. Issue of delegate is not justiciable. It's within the realm of a political party, domestic realm of the political party. A delegate cannot challenge any action in court. It's not, and it cannot happen.
So you also disagree with the judgment of the court that they be allowed to participate in the primary? It describes it as a declaration, by the way.
An act that was completed in February. You are making another in May, in June, July, that they should be allowed to participate. The judge knew that that primary had been concluded. He knew. And if you are now making another way into June, July, to say allow them to participate in the primary, which primary are you talking about? It is an academic exercise. And a court must refrain from making an order that is unenforceable, that you cannot enforce anywhere. So that judgment, to me, never clearly, they didn't, mind you, in their prayer before the court, if you look at the prayer that they went to court with, allow us, don't exclude us from participating in the primary.
So if it was merely academic, why is the PDP appealing the judgment?
Well, we are appealing the judgment because, one, let me state the fact now. That is a very good question. A lot of persons have asked. You say that judgment does not concern our candidate at all. Yes. For the simple fact that in future, we don't want precedent, bad precedent, to be laid, to say a delegate will wake up one day and hold a political party to ransom. That is the reason why the PDP decided to appeal that judgment, so that in future no one delegate can hide any place and hold the political party to ransom. It's not provided in our law that a delegate has a right that is justiciable in our law court.
Mr. Ejegba, yes, since we're talking about the future, because we're rounding off right now, since we're talking about the future, let's talk about the future of politics in Edo State and how this drama will actually tell the future of politics, especially knowing that this administration is already rounded off. By November, they're out, a new one will come. So laying this kind of foundation, we've seen what is happening in Rivers State and some other states in terms of politics. How would you think that the politics in Edo State going forward will play out?
Well, luckily for us, we have a governor who has performed very well. Governor Obaseki has done very well for the people of Edo State. And therefore, the PDP is a brand in Edo State. Our candidate has organic support. You don't need to beg anybody to come and vote for Anaso Ighodalo or Sarojo Ogi. I can tell you that going forward, the PDP will continue to rule Edo State. The PDP will win the 21st September election clear and clear on the first ballot.
Well, Mr. Ejegba, we've heard these words before, and I hope you're not jinxing it, because the PDP at some point said it was going to rule Nigeria for decades, I think 60 years. But of course, we understand that this is politics, and politicians will naturally make these comments. And just to say that we invited the other side, that's representatives of Mr. Philip Shaiibu, to also speak on this matter. Perhaps they'll join us in the coming episodes. But we'd like to thank you so much, Mr. Jimoh Ejegba. Not to forget that Mr. Shaiibu is declaring support for another candidate. So we'll just wait to see how these dynamics will play out in the election. But hopefully it will stay a peaceful election.
Didn't win in all the elections. Let him declare support for whosoever. That's why democracy is free to support whosoever candidate you want to support.
All right.
He has never won his polling unit.
Well, so Mr. Ejegba, we have to anchor at this point.
From anywhere.
Right. We have to anchor at this point. Of course, this is by no means the end of the conversation. We'll be speaking with Mr. Jimoh Ejegba, a legal practitioner, Deputy Director General, PDP Governorship Campaign Council. Also, he's been commissioner in the state. Thank you for your time on the program. We'll take a moment now. When we return, we'll talk about the manufacturing sector. I can bet you that where you are right now, you have something manufactured right there with you. So what's the state of the manufacturing sector amidst the biting economic situation? We'll find out, and hopefully to get a way out. So stay with us.